So good afternoon, everyone. Can you hear me? I don't think I need a mic. So I'm very pleased to introduce Professor Jiang. Professor Jiang is an assistant professor of comparative practice law at Bocconi University in Italy. His scholarly work, which combines deep theoretical insight with doctrinal mastery, spans contract theory and comparative business law across American, Chinese, and European legal systems. He has published in leading journals and books published by Cambridge, Hart, and Elgar. Professor Jiang is currently drafting a restatement of contract law for mainland China, Hong Kong, and Macau, while developing an innovative moral theory of contract law based on voluntary commutative justice. He has held visiting appointments at places such as Berkeley, the UI, and Yale. We are very happy to have him here today to talk about liberalism and justice in contract theory. Without further ado, would you join me in welcoming Professor Jiang?
Well, thank you everyone for coming. Yeah, it's a pleasant surprise to be visiting Hong Kong U. Despite I only have 1 day. The fact that I only have 1 day here. I was visiting Hong Kong U last year. I spent a month here, but it was Chinese New Year time, so the worst time to be here academically. Couldn't get a chance to present my work this time. Really happy to be back. Let me. I think I should. I don't know whether you have read the paper. Why don't I just assume that nobody knows anything about what I've written? Then I will tell you what I think is wrong with contract theory and especially liberal contract theories and my prescription for the problems we have. So let me start you with an experiment I was trying to do, and I did. It's not I use a fake case, a VNA case, where I post that case to practitioners, judges, and legal academics, and ask them how this series of cases should come out, and then this hypothetical should demonstrate what is wrong with contract theory today. So let me start with something fairly easy. So there is an old lady who is not well educated, who is ignorant, who is old, apparently not well informed person, but there's a door-to-door salesperson who knocked on her door, sold her a TV, a high-tech AI-powered TV. Right? Everybody writes about AI, but in my paper, that's the only place AI appeared. It has nothing to do with AI. Only that this TV is supposed to be high-tech, and she was convinced without the help of this salesperson, that would be good for her eyesight for one, because she has poor eyesight. Somehow, it's a mistaken belief she had that her eyesight could be improved by watching this TV. So she purchased the TV, but there are a few objections one might raise. One is supposedly it was just a stupid idea. It was an inadvisable contract. It was a fair price she paid, but she had a very different idea that couldn't be further away from reality. What this TV, what kind of benefit the purchase of this TV can convey to her. That's one objection. The other one is supposedly it's still a fair price. She didn't have enough money, so she had to pay in installments, 12-month installments. It was a lot of money to her, but it's a fair price. Only that after 3 months, she cannot afford to pay. She went on food stamps because of this bad idea. Could she get out of the contract just because she cannot afford it? The third objection might be she didn't know much, and this door-to-door salesperson did not advise her that probably it's not a good idea for somebody in her financial position to buy the TV. Could she get out of contract? Number 4, what if She purchased a TV, this time not at a fair price, but 400% of the market value. What do you think? Whether she can get out of the contract based on these 4 grounds? Modern contract theory does not have a clear solution, right? But you'll find doctrinal support across jurisdictions for all these ideas. There are theories that can back any of these positions up. There are cases that might allow you to get out of contract. For example, if you are just being stupid, it was an inadvisable contract. It's very much like the Bundy case. Lloyd's Bank was Bundy. But let me first show you the result. I did 2 sets of experiment. One is that I asked lawyers, judges, academics to give me reasons why the case should come out one way or the other. When I did that with Chinese judges, with Macau lawyers, it's 100%. The result was 100%. Everybody denied the relief just because you are being stupid. We don't let you out of the contract. And simply, there's no doctrinal basis for that. Number one. Number two, when you cannot afford it, I think also everybody will say the contract is binding just because you cannot afford it. You don't get out of contract. Number three, just because there's bargaining inequality, right? You get out of contract only when it is coupled with unfair price. If you have combined the third and the fourth factors or objections, then you get to get out of contract. Of course, there is more doctrinal support there. Take the American doctrine of unconscionability or the Chinese doctrine of 显示公平, which comes from usury in German law, and Macau has the same doctrine of usury, and in French law, there's economic duress that basically resembles unconscionability or usury, and I can go on and on. So it doesn't matter which jurisdiction you are in, unless you are in UK, unless it's English common law, then it's more difficult. Otherwise, in continental Europe, in the United States, if you combine bargaining equality with unfair price, of course, I think procedural unconscionability should go beyond bargaining equality. But usually, if you have unfair price, gross disparity, right, and exploitation, bargaining inequality, you should be able to get out of contract. So that's a survey I did, and I gave an online lecture a few months ago to more than 500 lawyers in Hong Kong. I didn't meet them, but I asked them to give me yes or no answer to these questions. So the result was about 20 to 30% of people will give relief. Most of them wouldn't. Will give relief to inadvisable contract when you are being stupid, or you can't afford it. It's 20 to 30%. Most of them will say you are bound by the contract. But if the price was unfair, 400%, right? The Chinese judges, the Macau lawyers, they will say 100% will give relief because it corresponds to our conception of usury. Hong Kong lawyers, they don't have a very good doctrine. You know that better than I do. But still, close to 40% of them will give relief. So now you understand that perhaps nobody knows what justice means in contract law or contract theory. People have very, very different ideas. That is a problem. So I'm telling you why I'm writing this article. It's really because we have very different conceptions of justice. And I would say the root problem was in liberalism itself. Now, let me talk a little bit about the liberal ideas of contract law, both on the left and the right. I use left and right to simplify other terms, such as if I want to say right, I mean libertarianism, which means that it's quite simple, that there's no people are not interested in the idea or conception of justice in contract theory at all. So long as you make a promise, the promise is enforceable on its own. It's a moral convention that allows you to maximize your liberty. In order to have that liberty, you need to keep the contract binding. You need to keep the promise enforceable. As simple as that. That's one extreme of liberal idea. On the right, that's Charles Freed, and you can there are some other people like Randy Burnett. We can talk about Alan Schwartz, who is an economist, but their idea is not simply it's in everybody's best interest to just enforce the promise. We don't ask the question of justice. That's the one extreme. What's the problem with that? Then you defer everything to people's wills, right? You defer everything to people's mental state, the intention, nothing else. That goes back to 19th century will theory. If that is the case, we can't explain contract law because there are so many default rules. There are so many technical doctrines in contract laws that have nothing to do with the promise theory. Take consideration, for example, right? So Charles Freed had to say his theory is better off if we don't have a doctrine of consideration. Hanot Dagang has to say the same for his theory to make sense. And there's offer and acceptance. When is an offer binding? When does the when do you have a contract? Is it a mailbox rule or the acceptance has to be received? Does not have anything to do with the promise. Does not have anything to do with will theory. What about implied terms of a contract? What about the contractual gaps? We're talking about mistake, frustration, impossibility. All these are very technical doctrines, right? Now allow people to work back on their promise to escape contract. Why would we do that if the only concern we have is to enforce a promise? That's why I don't think the people on the right, the libertarians, they can justify contract law, right? But that has been written, that has been said by my co-author for many years. My main attack here is on people on the left, the libertarian, egalitarian liberals. Means that they care about equality. They think there's social inequality in the society that's pervasive and that has to be adjusted by contract law. We need to help basically poor, needy people. Their theories go like this. There's relational justice theory. That's the more powerful one by Hanot Dagang. So he talks about this equal respect of self-determination. This substantive equality. Equality shouldn't be abstract. What does that actually mean in layman's terms? I think it only means that I can't be too mean to you as an equal. I can't treat you too poorly, right? And the prime example he uses is Jacob and Young versus Kent. Right, I have to ask, do you know the case? Right, I assume you don't. So it means that the contractor was tasked to build a whole building according to a contract. But in the contract, it's specifying that they have to use some brand of pipes. It turns out they use the same quality, same value pipes with a different brand. So can they be sued for a breach of contract or fundamental breach and be liable for the damage, or you rebuild? You give the non-breaching party enough money to rebuild the building? The court said no, right? So to relational justice, people, they care about bargaining equality, they care about a powerful party taking advantage of the weaker party. So they say you can't be too mean to the other. Otherwise, you don't respect each other enough. But it's not really what's at stake. I think what's really at stake is one party has this heightened sensitivity, right? It's a risk. Now you impose on the other party because every other human being on earth wouldn't care which brand was being used. It's a tiny portion of the performance, not inexactness to everybody else wouldn't be a problem, but it will be a problem to you. If that is the case, you're imposing a risk of your heightened sensitivity on the other without compensation. To me, it's economic unfairness. It's really very much like the Rockley case, the swimming pool case, right? Just really, most people wouldn't care whether it's a 1 inch shot or one inch deeper, but this person does care. That's shown that's true. If that is the case, relational injustice, I'm overgeneralizing here because I don't have another 30 minutes to go into the details, but it really means that it can only be measured by economic fairness, by fair risk compensation. Because another example is bargaining inequality exists in every single contract. Let's say I enter into a contract with Peter. Can I argue that, even though I'm a contract lawyer, but Peter is smarter, is more experienced, he has written more books, he knows more about it, so he was taking advantage of me. Even though I asked him to buy me a coffee, he bought me a coffee. Can I just get out of contract by saying there's bargaining inequality between the two? That exists in every single contract. I think even between Bill Gates and Elon Musk, you can still say possibly there's bargaining inequality between the two. But without using economic fairness as the measurement, we don't see what's wrong, right? The contract should be binding. I should pay Peter for the coffee he brought me. It doesn't matter whether I'm a student or I'm mentally ill. I want a coffee, I got a coffee at a fair price. What's my complaint? Just because the other person is smarter? So that's relational justice theory. Then there are other theories that are more extreme, more further on the left. One is Rebecca Stone, the other is Aditi Bashi. My problem with them is they're not interested, at least Aditi Bashi is not interested in transactional justice. It's about justice in a lifetime of a person. Then how can we use her theory to explain a transaction or individual case outcome? Her theory is weird in the sense it's called contract as exchange. She acknowledged that what I have been arguing and what my co-author and I have been arguing, that you can't change your price term of a contract. It's set by the market. No matter how much you love your house, you can't sell your house twice the market value. No matter how much you don't like something, if you want to buy a cup of coffee, you have to pay the fair market price. You have nothing, your independent will, your intention has nothing to do with the price terms. Those things you can't change. So she acknowledged that, but she also thinks you can't change the price, but you have to increase accessibility, which means you want to provide market access to people who can normally not afford it. So she talks about affordability. You understand you can't change the price, and you say you have to make everything affordable. Then what's the end result? Just think about my hypothetical, right? I made a stupid decision to buy something I cannot afford. After 3 months, I go on food stamp. Usually contracts should be binding doctrinally, but we have theories that says otherwise. Like Bashi's story will be telling you that you should be able to get out of contract because the contract law should empower you to have access to the market. But if not is the case, next time nobody will do business with you. And it sounds ridiculous, but I do find doctrinal support of her position. There is a California case called Carboni with a low spite. So in that case, a person was charged 200% interest rate to get the loan, because that's the only person who is willing to lend him the money because of his credit history. To help, he needed the money to help his relatives in Peru who didn't have health care. They needed the surgery immediately. So he got a 200% loan, which is a fair interest rate, given somebody with his credit history in that position. Nobody else would lend him the money, so it's the right price. So it's not unconscionable. The court was saying you could have got it for 20%, and yet you were being charged 200%. There's gross disparity there, there's substantive unconscionability. It is not true. Had he been able to get 20%, he would have gotten 20%. No, the fair price was 200%. But if the court every time says that you couldn't get health care, so we allow you to get money to get health care you need, then you don't have to repay the money. We let you out of a contract. The end result defeats Bash's purpose. Bash's theory wants people to have access. But if you do things that way, the first thing they lose is the market access. That's what I find contradictory. It's not liberal. Almost not, it becomes illiberal, and it won't serve the purpose. And there's Rebecca Stone's theory. It's called democratic consumption. What she wanted to do is even more ambitious. She wanted to cure every single injustice in the world in a contract transaction. She wanted to restore relational injustice, distributive injustice, and background injustice all at once. But think about it. If you care about economic fairness, you should be charged the same price, a fair price. Then you don't care where there's procedural injustice. If you charge people the same price, you don't care what background they came from, right? But if you do care about background injustice, every single time two persons contracted, you have to evaluate their IQs, their financial resources, to say now whether this contract is binding. Then you don't have a stable conception of justice. I think she also recognized that. So she wants to find the court to find a plausible version of justice, agreeable between the two parties every single time, to decide whether a contract is binding, to decide whether you can escape the contract, a binding contract. In that way, you don't have contract law, right? You have a moral position. She thinks that a lot of times a person defaulted on a contract was in breach, but because he was poor, there was no moral wrong. So ideally, contract law is wrong to hold him to the contract. Perhaps. But the fundamental problem here is not contract law. Maybe there are more deep-seated social issues that should be addressed elsewhere, outside of contract law. And she also thinks that poor people has vulnerabilities. But I would have to say, if you really want to be egalitarian, I think rich people have vulnerabilities too. I'm using one example borrowed from Daniel Markowitz. He was saying the same thing. He agreed with me, even though he's on a different side. So he's saying that he used to live in not such a fancy neighborhood in New Haven. And he later moved on to a much fancier neighborhood in New Haven. I think he always lived quite well. I don't know what he was talking about. But anyway, he said once he moved to this even nicer neighborhood, he started getting in the mails all these catalogs of very fancy outdoor chairs, outdoor furniture at ridiculous price, one chair for $3,000. But I asked him, why do you think these manufacturers can still stay in business? Are they legit? He says it's because there are too many suckers. Rich people are too busy. A lot of times they can't check the price. They're too busy to check the prices. Right? So if that is assuming what he said was true, rich people are vulnerable too. You can pay $1 for a coffee. And if they don't have the time to check the price, they're too busy doing other things. You stiffen with a coffee and you ask them to pay $100. It's not a vulnerability. I think equally, rich people and poor people, they both have vulnerabilities. I think this so those are the three theories I want to talk about, and also I wanted to talk a little bit about Daniel Markowitz and Alan Shaw's position. So Markowitz is on the left. He would say he's far left. Everybody who knows Alan Shaw knows Markowitz is a philosopher. Shaw is an economist. Ideologically, they are on two opposite sides, but they have the same theory. They think contract is enforceable so long as it produces a joint surplus. There's a joint gain between the parties. So long as that is true, the contract should be enforceable. What do they mean by this surplus? It means that whatever the other person was willing to charge and whatever you are willing to pay, there's a huge range of prices in between. At any given point between these two extremes, you are gaining something. Both of you, right, are getting something. One of his examples would be very rich people will pay a lot of money to babysitters because their time is more valuable. If you are a billionaire, 1 hour of your time could be worth a lot more. So even though they pay the babysitter a lot, the contract should be binding because it produces joint surplus. My position is different, and I think I convinced Alan Schwartz that at some point in his article, he agrees when the market really works, the contract price will be exactly the cost. The cost means the actual cost and the reasonable profit. That's what the economists call cost. So he will agree with me. If the market really works, it's transparent, it's free, it's competitive, you reach at one price, the market price. So I don't think we would reach different result. But for my theory to work, I think there's a just price. He thinks there's a range of prices. When the market functions, we agree. When sometimes in marketplace, you can't see all your options. Market price is not immediately detectable. Let's say it's housing market. You have seen enough houses, but you can't possibly see all the houses in the marketplace, right? There might be a slightly better bargain, but you are willing to put in an offer right now. You are willing to contract right now because you are afraid if you don't commit right now, the next deal is going to be worse. You're going to lose that bargaining position. You will lose your favorable bargain. To lend, it's probably drawing surplus. To me, it's fair risk compensation. It's still, you are reaching the just price. And you are being compensated to show that risk. If other people was in breach, they took away your favorable bargain because you lost that transaction, the next one will be less good. It's possible it's going to be less good. So it's like placing a bet at that price. You can't see every card so long as is a fair guess, right? You might win, you might lose ex post. Then you are bound by the contract. So that's my difference with Markowitz and the shorts. Now, do I still have time to talk about my own theory?
It depends. So you have about 1 hour in total for both your talk and Q&A. So the idea is that if you talk for longer, then we'll just have less time for Q&A. So
that's fine. It takes me 5 minutes.
Please go ahead.
But before I talk about my theory, one more thing I would like to say about other theories. Again, if you believe in libertarian theories, you can't account for contract law, period. If you believe in this left positions, this egalitarian liberals, they are Rothian inspired. I think it's philosophically problematic, and also practically, you a lot of times you confuse injustice with normal constraints in life, because I would rather say that I would fly to Shenzhen from Hong Kong, right? But you can't say there's injustice because I don't get to do that. I never checked, but I suppose there's no flight going from Hong Kong to Shenzhen, right? It's not because there's an injustice imposed on me. It's just really the market wouldn't allow it. It's a normal market constraints. It's normal constraints in life. You can't say it's injustice. I think Storm and Bashi sometimes they got very confused about what is life and what's injustice. About my theory is very simple. It's contract as voluntary commutative justice. It means that when it has to be voluntary, the contract has to allow you to get what you wanted, but at the same time allowing you to do so will not be economic unfair to the other party. So that's the gist of my theory. So we consider two or three questions. One is, what makes the contract binding? Second is, how can you escape a binding contract? The third is, sometimes you have to limit contractual remedies. How do you do that? The first question is, when you are fairly compensated to assume a risk under the contract, you are bound, right? We're talking about contract of exchange. So let's say a market price will fluctuate. Before the contract, you thought it was a good deal. It turns out after the contract, because of market price fluctuation, it turns out to be a bad deal. Are you bound? You are, because you don't need to be compensated for market price fluctuation, because that's an inherent risk. Everybody has to assume if they wanted to contract. Okay, if there's additional risk, then you need to be compensated for. For example, I use this case, Weaver versus Amical. It's a famous Indiana case in 1971. It means there's when somebody got a lease to work on a filling station from Amical, there's a whole harmless clause in the lease that says no matter what happens to you, you have to hold the landlord harmless. So what happened was because of the negligence of the employee of Amical, who sprayed gasoline on the lessee, he set the lessee on fire. The person got injured. But there's a whole harmless clause. You cannot go after Amical. It's not whole harmless clause enforceable. The court was saying no, right? Of course, the court will say, oh, you're a high school dropout, you didn't negotiate a contract, you didn't read a contract, you didn't have a lawyer advising you. But that's not what is really at stake, right? What's really unfair here is Amical imposed a risk of being burned, being set on fire while on a gas station on you, ex ante, without compensation, right? If you knew you are assuming that risk, you will do a few things. Either you don't work with them, or you need to be aware that you need a health insurance. You need an insurance policy to protect you. So the choice between you and Amoco is who is going to bear the cost of that insurance policy, right? If they were not trying to cheat Amoco, big oil, it's much cheaper for them to buy the policy rather than having this poor guy who has high school education to go out and get a policy, right? The reason they didn't mention that is that they didn't want to pay for that risk to be assumed by somebody else, and they used a technical term in the contract to trick him. So that contract is not binding. The court was saying it was unconscionable. And there are other cases where relational justice theories will say it's a violation of good faith, like Market Street Associates, and there's a French case. It's very similar. They use the technicality of the terms that the other party was not aware of, right? To expose them to a risk they will not pay to assume. So there is a in Market Street Associates. There's a term in the lease saying that the tenant has a right to ask for financing at some point for the improvement of the rental property. If the landowner denies that, it triggers a purchase option to buy the property, and that price is far below. It was far below the normal price. So the landlord tricked the landlord. When they submitted the request for financing, it was denied because the landlord was not aware of this term. And they say, now it triggers our option to purchase the property. The court was saying that's a violation of good faith. But what it really does is the contract did not allocate that risk of in momentary inattention to one party or another. Here, it was not intended. Then you use that technicality to trick the other party out of something valuable, right? It's unfair risk compensation because there was no compensation for the landlord to assume that risk. So they say it was against good faith. I think it's unfair. So now you have a fair contract. How do you escape the contract? There is an umbrella term of change of circumstances. In every jurisdiction, you can have one or the other, or both doctrines. One is hardship or commercial impracticability or frustration. Either way, I think it can be explained by my principles. If it's frustration, it's about if you couldn't get what you wanted, your principal purpose is frustrated. You should be able to get out of contract in principle, unless allowing you to do so will be economically unfair to the other party. And the conation cases, the two famous conation cases, illustrate that principle. So if I paid, that was before you have Airbnb. You paid suitably enhanced price to stay in that flat for no other reason but to watch the parade. Then the king got sick, right? The parade was canceled. Can you get out of the contract? I say yes. Why? Because there's no other reason for you to want to rent that flat for any other reasons for that night. And allowing you to do that will not be economically unfair to a landlord, because if we assume that is the case, no other person will rent that flat for that reason and that price for that night as well. So he didn't lose the bargain. That's how I explain that case. Hardship is a different formula, but still the same idea. Under the contract, you assume certain risk, but if the cost of performance goes beyond the risk you assumed under the contract, then you are not compensated enough to assume that risk. I won't go into the details. I just want to talk about one last principle about a limitation you put on for recovery of expectation damage. I often give students and my survey participants this example, which is, let's say you are Elon Musk. You jump on a taxi. you ask the taxi driver, do you recognize me? The taxi driver will say, oh, you are Mr. Marx. I saw you on TV all the time. Oh, I'm glad you recognize me. I'm going from, let's say, JFK to Empire State Building to meet with Bill Gates. We are going to have, we are going to sign a $1 billion contract. If I were to be late, he has another important meeting. I won't have a contract. Do you understand that? You have to bring me there within 1 hour and 15 minutes. The driver was saying, no problem. I guarantee you. Then he was 15 minutes late. Bill Gates took off. Elon Musk lost a $1 billion contract. Can he sue the taxi driver and the taxi company for the expectation damage? Every legal system will say there is a cap, and that cap is foreseeability, right? You could all say that, oh, it's foreseeable. Oh, it's unforeseeable that he will be liable for this astronomical consequential economic loss. But it's not true. If he has been told expressly about that astronomical consequential loss, how can you claim it's still unforeseeable? What's truly at stake here? Again, unlike all the other liberal theories, all I'm saying is fair risk compensation. If you have been paid to assume the risk, and that risk matures later on, you cannot renege. But here, clearly, if you are paying the normal taxi fares, apparently you didn't pay the taxi driver to assume the risk to be liable for that astronomical loss. So it is unfair. So in American law, right, American law here is an outlier. If you check restatement of contract, second restatement of contract, section 351, the last section will say expectation damage should be reduced to reliance damage to prevent disproportionate compensation. I think that is the true story here. It's about fair risk compensation. Otherwise, it's disproportionate. So that's my story. Okay.
So thank you very much. And thank you most of all for Professor Jiang for the excellent presentation.